Docket 25516 FC, People of the State of Michigan versus Siobhan Hanks. Counsel, your appearances for the record.
Good afternoon, Nicole Matusco on behalf of the people.
Good afternoon, Your Honor. Jacob Sartz, the fourth Assistant Public Defender, here on behalf of Mr. Hanks. He's present at the podium. He's standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. This is a motion to reduce bond. Is that correct?
That's right, Jen.
That's correct.
Prior to this, sir, however, you seem like such a nice young man.
At first glance, this hearing looks like a routine bond motion. But the moment the judge starts talking about letters, you can feel the tension shift inside the courtroom. Judges deal with frustrated defendants every single day. People get angry about their cases, about delays, about plea deals. That part isn't unusual. But what is unusual is when that anger turns into direct attacks against the very people involved in the legal process. And that's exactly what happened here.
I will read some of it to remind you of the disrespect that you have shown. Here's a letter that starts out, "Hey, bitch, Matusco."
Hearing those letters read in court is honestly shocking. This wasn't just frustration. This was raw anger, insults, and even threats directed at the prosecutor. And the moment something like that enters the record, it changes the entire case. Because the court now isn't just looking at the crime itself, they're looking at the defendant's behavior and potential
All letters I wrote you, and I will read them in court with a big smile. I don't see you smiling now, sir.
One moment in particular stands out when the judge asks him a simple question about his mother. It's not about legal arguments anymore. It's about empathy. The judge is trying to make him understand how those words affect another human being.
Angry words, those fighting words. The answer's no. So y'all can make your record. But when I look at this, I look at danger. I look at threats. A lot of anger. We're going to get this resolved. I don't know what's going on here. I think we've had a few pretrials, haven't we?
We have a final pretrial and a trial date set. We have our final pretrial set for mid-March, Your Honor.
It's March 11th, Your Honor. We have a final pretrial with a trial date in April.
So shall we have the final pretrial? And in regard to these letters, I'm thinking maybe we have contempt. These are threatening. Contempt carries with it 93 days and or $7,500.
Well, Your Honor, we are still attempting to negotiate a plea offer here. I would simply respectfully request that we keep that window open until that March 11th date. It's my understanding that Madam Prosecutor would like to meet with the complaining witness again and then extend a final offer. We have been negotiating in good faith on both sides. Certainly, Mr. Hanks' alleged statements here have added another layer of complexity here to the negotiations, to put it mildly, understated. But respectfully, Your Honor, we are making every effort. I'm making every effort on my end. So is Chief Deputy Matusco, to try to see if we can find some common ground here to resolution before a potential trial date, which we have set. And I will be prepared and able to proceed with the trial on that date if needed, Your Honor.
Ms. Matusco, are you asking for contempt?
And for a moment, you actually see a different side of the defendant. He admits he was angry. He admits he wasn't thinking clearly. But in court, sometimes the damage is already done.
You've been in front of me before. You've always been respectful. So I don't know what's turned. I am sure that it's very difficult being young and in jail. But you see, we have a retail fraud. Height was revoked. You have defrauding an innkeeper. You have CSC fourth degree by force or coercion. We have, do we have a pending charge? We have 2 files.
Your Honor, the pending charge was when he was out on tether. He caught his tether and was found in possession of cocaine. So the pending charge is having cocaine in his pocket.
So you got drugs? And you've already acknowledged in here that you were high and not making the best decisions. So you got to address these issues, and we're going to have that happen in jail right now. Is there a final offer, or are you still working on that?
Your Honor, it's my intention to meet with the victim in this matter. We've been working around work schedules and my own personal schedule within the next week, so that I will convey that final offer
I have a final pretrial this last September, so I don't know what happened, but I know there's been a lot of changes and other things that have happened, so.
So I can address that.
Okay,
Previously, this case was being handled by Dale Caldwriter from my office, who was the assigned prosecutor in this case. Mr. Hanks made the decisions to write him letters as well. So when I was covering this court, I took this case over to remove Mr. Caldwriter from the file to hopefully stop those letters from happening. Those are not attached to this motion, as I only wanted to update the court as to what has transpired since the last time this court denied bond. And it's clear that the letters were getting more threatening once they were directed towards me. So I took this case over in September. Mr. Swartz and I began negotiating, exchanging information, mitigating information, discovery, to see if we could get a resolution in this case. So that's why that final pretrial was adjourned back in September.
all right, March 11th, final pretrial. You're here,
Yes, Your Honor.
and then when is the trial?
It's April 24th.
Probably 4 or 5 scheduled that we did, and I don't think that, I think a couple of them are older than this, so we need a couple backup dates unless you want to prioritize this because he's in lockup.
I will work with Mr. Buxton to see where we are on the list and then communicate that to Mr. Sartz as well. If a backup date is necessary, Mr. Sartz and I can work the schedule to get one.
You're remanded to the jail, you're gonna work with community mental health, see medical, psychological, go to CATS, get some treatment over there, sir.
This is the moment the case really changes. Because once a threat enters the record, the judge has to think about safety, not just
Right.
fairness.
Don't be rude, crude, angry. We didn't commit the crime. You're innocent until proven guilty beyond a reasonable doubt, but for bond conditions, I have to look at public safety. What I see here is not safe. You're entitled to your trial and you're gonna get one. But I also want you to consider these letters that you admitted bad behavior, criminal behavior. So I don't know how that's gonna play in. But you didn't do yourself any favors, sir. You said who you were, you wrote these, and you talked about what you did. Those statements can all come in at trial. There's any pretrial notion about motions that this isn't gonna come in. Set it in front of me, but I don't know how you get around this from coming in if people wanna bring it in. You can talk about that with your client, you need to talk about that with your attorney. Have I made myself clear, sir?
Yes, you have.
Very good. Is there anything else we need to address?
Yes, Your Honor. I believe we addressed it at the December court hearing. The no contact order for a witness, well, sometimes the co-defendant. I know Mr. Sartz and I have worked to get her an attorney appointed because some of the letters implicate her as well. I just want the court to reaffirm that no contact order and make it clear to Mr. Hanks that that includes reaching out by way of a third party. He recently made phone calls to a third party to make contact. That third party did cut him off, would not engage in much of a conversation, but I just want to make it clear that any contact, whether directly or indirectly with Ms. Hill, would violate this court's order.
Do you understand the no contact order? And Ms. Hill was already added. I have a note here, a potential witness, and she may have some culpability. We need competent counsel for her.
And
So-
and she may have some culpability.
Culpability, and we need competent counsel for her. So I don't know if that's occurred. It should have. This is my notes from last year.
It has, Your Honor. I believe the public defender's office was quick to provide her with competent counsel.
Sir, no contact with any witness, defendant, victim. You're not doing yourself any favors. Taking all your anger out on yourself. The only one you're hurting is yourself. Stop doing that. Help your attorney provide a defense. That's your job.
And Your Honor, that would include third-party communication or handwritten letters that I will note for the record are scanned by the jail.
Are you gonna have trouble not complying? Are you gonna have trouble complying, I should say?
No.
You understand no communication through third party? You understand what that means?
Yes, I do.
No contact means you don't exist in your world. No carrier pigeon, no smoke signal. No Hallmark cards. No letters, phone calls, email, text. Contact through third parties. They don't exist in your world. Have I been clear, counsel?
Yes, Your Honor. Thank you.
Any questions?
No.
That's all for the record, thank you.
Thank you, Your Honor.
And just like that, the bond is gone. Those letters didn't help his case. they may have completely destroyed it. By the end of the hearing, the judge makes something very clear. This case isn't just about a robbery anymore, it's about the decisions someone makes after they're already in trouble.